Hello and welcome to the Rogers Brief for November 12th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I hope everybody had an opportunity yesterday to take a few moments to pay their respects to their military veterans. Certainly a poignant time in a sense because of all the turmoil going on, the war in the Middle East, Israel and Gaza, and of course echoing some of the terrible themes from World War II and some of the ancient prejudices that seem to be persistent despite many efforts to rid our planet of them. And anyway, we'll hope for better things to come in the future. But anyway, I'm not going to be talking about that in this video. Just wanted to mention that off the top. Another a programming note, I guess, to start with. We're not going to be doing the Sunday night show tonight. And a message from Jordan that he's away for a couple of days. I'm sure he'll be putting that out on his social media channels as well and on YouTube, that there will not be a YouTube live show tonight. So we'll be back next Sunday though with Jordan Bonaparte and Paul Palango on the Sunday night show. Always enjoy hanging out with those guys and talking about some interesting stories. So a couple of those stories I'm going to try to cover in this video here. One being the Cameron Ortis trial. This is I described this guy last Sunday as sort of a Ethan Hunt, James Bond spy kind of, I don't know, upper. He was high up in the Canadian secret intelligence world and is now on trial. So I'm going to talk about that in a minute. I'm going to talk about a few cases. This voyeurism charge. Conviction out of British Columbia. I mentioned this last Sunday night as well. And I'm going to talk about a report out of a parliamentary committee, the National Security and Intelligence Committee on the RCMP in Canada, and the way the RCMP is structured. And it's been it was quite a stark report, so I'll talk about that. And it came from a committee chaired by a member of Parliament. I'll talk about some cases, this voyeurism charge out of BC, also a couple of cases in Nova Scotia with large amounts of money stolen and some of the consequences of that. One person is currently facing a potential jail sentence. Another person may be, if she doesn't make efforts to pay back a very large amount of money stolen from Millbrook First Nation. And then I'm going to get into this case of Dr. Fashoranti. This is an Amherst, Nova Scotia doctor who was charged with sexual assault of 3 different people. I talked about this case last year where it was subject to a stay of proceedings. Well, the Crown appealed that situation and went to the Court of Appeal, and we have that decision this week. And it was sort of some interesting legal issues on what it means to have a stay of proceedings in a case, the effect of that, but also some troubling behavior by the Crown prosecutors and the Crown office in this case, which led to the stay and which led to the Court of Appeal affirming that decision. But I'll talk about that. It's a situation I think that's going to provide some good guidance to judges and lawyers going forward. But let's start with the sitting of the Nova Scotia Legislature. Fall sitting ended this last week. It was only 19 days. This is not unusual now for sittings of the legislature to be short as possible, it seems. 19 days is not, it's only a few weeks' time, 4 weeks. Long days too, and this led to some acrimony among the parties. So long days, right up till midnight each night. The legislature was sitting, and the government wants to do that because they want to get their legislation passed as quickly as possible and get out of there. Each day that the legislature sits means that's one more day where the opposition parties can question the government in question period. And of course, question period is where most of the attention is gathered for, media, for the public. This is the clips that often make the news are the question and answers. And so if you have a normal workday kind of a session to pass legislation, end at 5 or 6 p.m., then instead of 19 days, maybe you'll have 29 days. So that's that many more days for the opposition to have an opportunity to question the government in the legislature. Government doesn't like that, despite when they were in opposition having the same kind of complaints as the opposition is now having. All right, so what happened during during the fall session? There was some legislation passed, housing legislation that gave a lot more power to the Minister of Housing. I know HRM, Halifax Regional Municipality, is unhappy with that. There's some municipal finance legislation that changed the way municipalities are funded by the provincial government. CBRM, Cape Breton Regional Municipality, is not happy with that. So we have the two largest municipalities in the province with some problems with the provincial government. There was a opioid class action legislation passed. So this allows the province of Nova Scotia to join in with a class action lawsuit that started out of British Columbia. Other provinces are joining in. This is against manufacturers of opioids, similar in nature to the class action that was done against tobacco manufacturers a couple of decades ago. And so we'll watch to see how that unfolds and how the province is going to be joining, whether they're just tagging along or whether the Nova Scotia government is going to make their own, special effort in that class action. Certainly we'll need to gather evidence of the effects of opioids in Nova Scotia and Nova Scotia citizens in order to show what kind of harms have been brought upon us, the expenses of our health system, the extra expenses of our health system in dealing with these addictive substances, which, of course, the manufacturers knew to be more addictive than they were letting on. All right, so we'll see about that. Now, halfway through the mandate of this provincial government, they're still way up in the polls. Opposition parties, whether through either lack of organization or they just haven't found the right issue to attack this government, have not chipped away much at the popularity of it. So we'll see. We're halfway through the first mandate. There'll be an election in under 2 years' time now, so we'll be watching for the spring session and next year to see how all the parties adjust their messaging to reflect where we are in the election cycle and what issues are still out there. Okay, next I want to talk about some specific trials. First is this Cameron Ortis trial. Cameron Ortis was the director of RCMP Operations Research Group. So he was a high-level criminal intelligence individual involved in, international money laundering investigations, some big money involved in these billions of dollars alleged to have been laundered, and people using these burner phones and such, criminal organizations throughout the world, tied back to Canada. A lot of pressure on the Canadian intelligence services to show some results. And so they've charged Cameron Ortis with, under the Security of Information Act, with providing details on an investigation into money laundering to one of the subjects of the investigation, and saying basically, hey, here's some details. If you want the unredacted version of this, then send me $20,000. Okay. As I mentioned last Sunday night, they were talking about billions of dollars in transactions here, and for Cameron Ortis, a high-level government official, to risk his position over $20,000 seemed absurd. I thought it was going to be $20 million, but $20,000, which seems to support his contention. So this is Cameron Ortis is making his defense in this trial, and he's saying that he was doing this to try to expose moles within the RCMP. that he had information from a reliable ally, likely somebody in the Five Eyes, which is the United Kingdom, United States, Canada, Australia, New Zealand, intelligence services that share information with one another, although less so. And Canada's really been on the outside. There was a recent communique issued about the situation in Gaza, and Canada was not even included in it. And so that and other things seem to be showing that Canada's on the outside looking in on these Five Eyes discussions. And I wonder if some of this Ortis, the stuff that's coming out in the trial, is connected to that. So Ortis is saying that he was trying to figure out who the moles may have been in the RCMP, and he was trying to entice these targets to use an encrypted email. He was telling them it was an encrypted email. What it in fact was an email where the Canadian intelligence services could track that and see who they were communicating with and so on. And Ortis says further, he couldn't tell his superiors about exactly what he was doing because he wasn't sure who the moles might have been, and he was trying to figure that out in the course of his work. And, here's a guy with a unblemished record and, was seen as one of the bright lights in our intelligence service, and they've turned on him and they've charged him and really destroyed his career over this. So we'll see where it goes. I mean, this is an ongoing trial taking place in Ottawa. Ortis has a very good defense lawyer, seems to be mounting an effective defense that makes sense. So we'll see. A lot of the information I suspect, I'm concerned, I guess, or thinking will not be made public because of the secret nature of it. Some of that may be done in camera with the judge, but hopefully we'll get enough so that we know whether this was a reliable verdict, whichever way it goes when it comes out. All right, so related to that in a sense is the next story, which is the National Security and Intelligence Committee, chaired, as I mentioned, by a Liberal MP, David McGuinty, is Ottawa area MP, brother to former Liberal Premier Dalton McGuinty in Ontario. So the report is about the RCMP and the structure of the RCMP, and the report says that the RCMP is too focused, almost exclusively focused on contract policing, which is providing police forces to rural Canada under contracts with provinces or municipalities, feeding a detachment, rather than federal policing, which is, cross-border crime, money laundering, these higher level, more complicated investigations. And it says, the report says the officers are trained at depot for 6 months and that they all go to a detachment and they do regular day-to-day policing. And nobody is trained specifically for these other roles on money laundering and tracking and, the new world that we're into, and certainly other countries are into, and we have to try to keep up. So, attempts to infiltrate the RCMP or other police forces, like is being alleged in the Cameron Ortis trial, are going undetected. And so there really seems like there needs to be an overhaul. I don't see any, this was in the National Post, it was in CBC. I saw the article was up in a few places. Didn't see a lot of leaders, the Prime Minister, others being asked to react to this. It certainly did not dominate the House of Commons this week, and there doesn't seem to be anybody on the other side other than the committee itself that's pushing for serious reform in the RCMP of this nature. But this was a stark report suggesting these changes very much need to happen. Also echoed something we heard in the Mass Casualty Commission about a lack of oversight for police forces, the RCMP in particular, from the civilian side, and that should be bolstered as well. So we'll watch to see if anything really arises from this committee report. Okay, some cases to discuss. First one, I mentioned this last Sunday night with Jordan and Paul, but this is a voyeurism case, which came out of Vancouver. Very unusual case. Publication ban on names involved, and that's because it was a highly contentious divorce, a high conflict divorce, and the husband had hidden a camera in his bedroom, the bedroom he shared with his wife, or at least occasionally shared with his wife. She discovered it. So the camera was hidden in a clock radio pointed directly at the bed. And the guy he admitted to the police that that's what he was doing. He was trying to catch his wife cheating on him, and that he had placed the camera there for that purpose. Well, you can't do that. That's 162 sub 1 of the criminal code says it's a violation of the voyeurism laws if it can be reasonably expected to be, if a person can reasonably be expected to be nude or engaged in sexual activity in a particular place. And the judge said, well, this is the bedroom. That's exactly where such things are expected to take place. And so no problem making it the voyeurism charge. And it was a motion detected camera as well. So it was designed specifically for her to, while she would be in there. The judge said it does not have to be for a sexual purpose. Normally when you think of a voyeurism charge, it's somewhere where the perpetrator is trying for their own sexual gratification to intrude on the privacy of another. See this in bathrooms, bedrooms, or through windows and such. But it doesn't have to be for that purpose. Of course, there's a sexual element to it, but it wasn't for the sexual gratification of the viewer. Now, this guy had also been charged with criminal harassment. He was charged with that because he was, alleged to have been following his wife around. He was alleged to and did place an advertisement in a local newspaper saying that his wife was planning to abscond with the kids, to take off with them out of the jurisdiction, and that people should be watchful for that, which of course would be highly embarrassing to the spouse, to his wife, and to the children. And no doubt that is one of the reasons why there was a publication ban in place for this, because those poor children, that would be something that would stick with them the rest of their life, and may yet, even with the publication ban. So the surprise to this, to me, is that the guy was sentenced to a conditional discharge. A discharge is where you basically live under probationary conditions for a period of time, in this case a year, and then at the end of that you don't have a criminal record. Your conviction is wiped away. Usually done for very low level offenses, and one of the conditions needs to be, one of the prerequisites is that it needs to be not contrary to the public interest that you receive a conditional discharge. So that seemed a little odd here. The guy wasn't even there for his sentencing. His lawyer was not there for his sentencing. So that's further unusual. Around here, in order to get a conditional discharge, you usually need a pre-sentence report that speaks very highly of the individual. You need some sort of a rehabilitative plan for them, that during the year that they're going to do certain things in order to show and demonstrate that they're, remorseful and all these things. And still, it's very difficult to get a conditional discharge. This guy got one. He's living in London. His lawyer didn't appear. He didn't appear. And, just given the nature of it and the high conflict nature of the divorce, it seemed like that he was probably deserving of a criminal record as a result of that, but not to be. Okay, next case I want to talk about is back here in Nova Scotia on the East Coast, and there's two cases that are sort of related, and it talks about it's on the question of very large fines and what happens. So we have one, the decision this week was related to the Millbrook First Nation and their former senior finance clerk, Dawn Ellis Abbott. And she, over the course of 6 years, from 2013 to 2019, stole $3.2 million from Millbrook First Nation. Used it for personal expenses. She owned a beauty salon. She used it for those expenses. She had horses, and so horse expenses. Family took trips. She paid off hers and her parents' power bills to the tune of almost $25,000. Lots of money. So, over $500,000 a year on average. Question will be, will she be able to pay that money back? If she looks to this case of Quentin Sponagle, that was also in the news this week, she may wish to try. Quentin Sponagle was convicted in 2017 of stealing $1.1 million from client investors. These were people mostly from a church in Sackville, parishioners there, fellow parishioners of Mr. Sponagle and his wife of the Rock Church in Sackville, and stole the money from them. He fled to Panama, and he was in jail for 20 months in Panama, fighting extradition to Canada unsuccessfully. Now the question, so now he had 5 years to pay back the 1.1 million, and failing which, if he didn't pay it back, then he was going to be subject to potential jail time. Well, he's paid back $10,000, so a very small percentage of the total, claiming now that he doesn't have the ability to pay. So what the court needs to figure out now is whether, if he just doesn't have the ability to pay, and that's reasonable, well, he can avoid jail time. But if he had the ability to pay and is choosing not to, then he goes to jail. So he's now claiming, even though he said the opposite of this at the time in 2017 and since, that he's been claiming he's got plans, that they just haven't come through yet, and he's got these ideas. But now he's claiming in the hearing itself that he doesn't, that he's been working a little bit of construction work, he's not making very much money. His wife is working house cleaning. She's not making very much money. Although his wife, she testified that she didn't even know who her husband was working with and how much he was making or anything like that. So that really kind of undermined his credibility and his case, but we'll see what the judge does with it. So I guess if somebody was advising Miss Ellis Abbott, one would say, try to pay some back, or else you might be at risk of going to jail, as well as I believe we will see Mr. Sponagle spending some time in custody. Although apparently they're going to take into account the 20 months he spent in jail in Panama at a particularly nasty prison down there. But we'll see, probably not entire. Probably we won't get full credit for that, but we'll watch for it. We'll wait for the decision, which will hopefully come in the next few weeks' time. All right, last case I want to talk about. I talked about this case last year when there was a stay issue. And this is the case of Dr. Fashoranti, a doctor up in Amherst. Seemed to be well supported in the community by people within the hospital and within the community. That doesn't always mean much, but sometimes it does. So is a decision this week from the Court of Appeal, Nova Scotia Court of Appeal, Justice Farrar, Van den Eegen, and Justice Ann Derrick, who wrote the decision. Crown was Mark Scott. Defense lawyer for Dr. Fashoranti was Stan McDonald, who also represented him at the trial. It was a different Crown. I think it was Jody McNeil at trial. But anyway, well, it's kind of relevant, but it doesn't matter in this analysis. So the question is, what is a stay of proceedings? Well, there's two kinds. One is a Crown stay. And I had this come up in a recent appeal myself as well, where so there's a Crown stay and there's a judicial stay. When the Crown issues a stay of proceedings, it could be for any number of reasons. Maybe a witness can't be found, or there's further investigation to take place, or there's something going on, and the Crown stays the charge. What happens there is that they have from that point 1 year to bring the charge back, and if they don't, if the year comes to a conclusion, they haven't brought the charge back, the charge is finished. And the other kind of stay is a judicial stay, and the judicial stay is usually done when there's some sort of abuse of process. There's something about the trial that makes it fundamentally unfair to the accused, and the judge decides, well, this is too much, and they issue a stay, and that's it. It's over if that happens, because if it's something so fundamentally unfair to the accused, then the theory is there's nothing that can happen to bring it back. Okay, so what happened here? Dr. Fashoranti was charged by 3 different people one from 17 years earlier and two more recently. The one from 17 years earlier involved a lawyer, Mary Ellen Nurse, who was representing the complainant, the plaintiff, and was trying to start a civil action against the doctor. Was in charge with was in touch with the Crown Office and the police at the time. Why aren't you charging? Give us an update. What's going on here? But then she becomes a Crown prosecutor years later, and the allegation is that she was involved in either advising, pressuring, or somehow involved in the decision to charge Dr. Fashoranti more recently with these other two, and the third one from 17 years ago, her former client. Well, so she did not, Miss Nurse did not represent the Crown at the trial, but the allegation was that she communicated and advised on whether to lay the charge in the first place. So, defense lawyer says, we want any communication that went back and forth from the Crown to the police that preceded the laying of these charges, that involved any advice, any guidance, we want to see those. And Judge Alain Bégin from Truro agreed, said, yes, Crown, give me that information. It's relevant to a potential abuse of process claim here, and it should be disclosed to the defense. The process the judge directed was, Crown gives the communications to the judge would review them for privilege, hand over anything to the defense that was not privileged. The Crown decided at that time that they would not provide the information to the judge. They said that at the time, and they invited the judge to enter a stay. So what does that mean when the Crown invites the judge to enter a stay? Is it a Crown stay or is it a judicial stay? So that was sort of a question in this. And then, can you even appeal from that kind of a decision? So normally a decision that's made during the course of a criminal trial is called an interlocutory decision. On, evidentiary questions or any of these things can happen in an interlocutory decision, and those don't get appealed. The question here was, can this one be appealed because it effectively ended the trial? Okay, so on that question about whether it could even be appealed, the Court of Appeal said yes. This is different than normal interlocutory decisions because it effectively brought an end to the trial. And so you have what they called a functional appeal, which is a rare thing because like I say, it brought an end to the trial. And so it's not, in a sense, an interlocutory decision in that sense. It is a final decision. Okay, so we'll agree with that. But then the next question is, well, was it proper for the judge to enter a stay, and what can happen now? They say yes, it was proper for the judge to enter a stay, and that effectively the Crown, by refusing to provide the communications at all to the judge, and there was a comment to the effect that the Crown made that to the defense counsel, like basically, you got what you wanted here, that they were effectively admitting that there had been an abuse of process. If they're not even going to provide the communication to the judge to review, well, you're more or less saying that Miss Nurse was involved in the discussions, in the advice, that was improper, and that it was perfectly correct that the trial be ended over an abuse of process. And Dr. Fashoranti's rights were violated pretty egregiously as it turned out, and it was proper that the stay be entered. So that's what the Court of Appeal decided. It was interesting when it's been in the news a few times, Dr. Fashoranti's case. He was subject to complaints with the medical board, criminal charges, all covered. This successful appeal this week didn't really make the news. I was a little surprised by that, but I thought I'd cover it because that's part of my role here, is to look at the things that are not obvious or not out in the public as clear as maybe they should be. So Anyway, hopefully I've explained that to you as well in a relatively clear sense of what a stay of proceedings is. All right, so that's it. So like I say, no show tonight with Jordan and Paul. We'll be back on the Sunday night show next week, and I'll be back with the Rogers Brief as well. So appreciate everybody sticking with me, and thank you again for watching. Thank you for listening, and we'll see you next time.